Hello friends, in the series on the income tax cases, today we will discuss the case of Assistant Commissioner of Income Tax versus RISHAV DUTTA. This case has been reported in 104 ITR Tribunal, short note 65. The matter has been decided by PATNA ITAT and the date of the judgment is 6th June 2023. The purpose of discussing this case is that this case shows that it is very important for any assessee to present and to submit maximum evidences at the time of assessment proceedings. If the assessee do not submit the evidence at the time of assessment proceedings and when the matter will be before the CIT appeal, then if the assessee submits the evidences, then it will be technically termed as additional evidence. And it is the general procedure of income tax proceedings that whenever the assessee submits the additional evidence, then the CIT appeal has to take the remand report from the assessing officer before giving its verdict. Although it is said that the CIT appeal has all the powers coterminous with the assessing officer, but in the fair play and in the interest of the justice, it is said that the CIT appeal has to take the remand report from the assessing officer. Although in this due process of taking the remand report, it takes a lot of time, because whenever the remand report is seeked from the assessing officers, they take a lot of time because they have a number of the tasks in their hand, and due to which the CIT appeal gets delayed. In this case, the assessee was a distributor and wholesale of branded tobacco business. During the survey on the assessee, there was some differences in the stock of the assessee and in cash balance. When the assessment proceedings were going on, the assessee was not able to submit all the evidences, so the additions were made by the learned assessing officer. When the matter was before the CIT appeal, the assessee submitted the confirmation stock statements of the tenants which supported the difference in the stock. The assessee also submitted the cash book which was explaining the difference in the cash. Apart from this, the assessee explained the methodology of recording the sales and value added tax at the time of the CIT appeal. The CIT appeal did not consider the effect of section 145 read with section 145A clause II read with ICDS 4, which is on the revenue recognition, and passed its order without seeking the remand report from the CIT from the assessing officer. The CIT appeal considered the additional evidence, but without seeking the remand report from the assessing officer, the CIT appeal gave its verdict. In this case, the assessee also submitted some additional evidence of ATC deductions which the CIT appeal considered and deleted the addition on that part also. When this matter was before the ITAT, it was the main plea of the department that the CIT appeal has given its decision without seeking the remand report from the assessing officer, which is against the principles of natural justice. So when the Patna ITAT heard this matter, Patna ITAT remanded this matter back to the CIT appeal and directed that the CIT appeal should have taken the remand report from the assessing officer in the interest of fair play and principles of natural justice, because the assessing officer has not been given the sufficient opportunity to keep its point. So friends, although the CIT appeal has given the relief to the assessee, but this matter was remanded back again to the CIT appeal just because the CIT appeal has not taken the remand report. If we go by logical reasoning, then when it is said that the CIT appeal can take all the actions which the assessing officer can take, then if the CIT appeal has considered all the evidences in the true sense, then in these type of cases, practically there will be no use of seeking the remand report. But this is the law and it only delays the process of justice and the matter of the assessee gets stuck at the CIT appeal for very long, for a period of 3 to 4 years. It is very general nowadays. At the end of this video, once again, I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus RISHAV DUTTA. And this case has been reported in 104 ITR, Tribunal, short note 65. The matter has been decided by PATNA ITAT and the date of the judgment is 6th June 2023. Thank you, friends.